circus. It's astounding to me that the government, with a straight face nonetheless, has presented this constitutional graffiti as some kind of significant and important reform. It isn't. It's simply posturing and legislative virtue signalling of the worst kind. The primary principle that guides the Liberal Democrats is that individual liberty is the foundation of a society that functions and flourishes. The Declaration of Independence in the United States got it right when they stated inalienable rights to life, liberty and the pursuit of happiness, and that the role of government is to secure those rights. How our government acts to secure these rights, at least in principle, is guided by our constitutions. The documents that outline how a parliament is elected, what its makeup is and what powers it has. These are fundamental documents that shape our democratic institutions and, through the governments empowered by them, our society itself. I watched with interest the debate in the other place. I wanted to better understand the government's arguments for making this change to our constitution and hear members' views about it. Unfortunately, the constitution barely got a mention. The Greens talked about how they were champions of fracking bans, but wanted to ban more stuff, like conventional gas exploration and development. The government talked up their climate change policies, gave themselves a pat on the back, conceded that fracking is already banned in Victoria, and then talked up the bogeyman of a future Liberal government to justify why this bill is absolutely necessary. In a telling admission, the member for Bass stated, and I quote, "Victorians believe that when legislation is passed by a government, it becomes the law. Victorians also believe that the law should not be subject to the whims of a change of government," end quote. This really is telling on themselves. Members of this government genuinely believe that they should rule us from the political grave. The future will of the people be damned. It goes to the heart of one of the key concerns I have with this bill. It is fundamentally anti-democratic. In their contributions, the opposition, in a standard tit-for-tat, pointed out that it was previous Labor governments, correctly, that approved fracking licences, and their party has a long-standing position of opposing fracking, which is also true. There are a couple of members who made some excellent points about the dangerous precedent of enshrining government policy in the Constitution, which I totally agreed with. They made excellent points, some of which I'll expand upon shortly, just before they huddled down in the corner like a punch-drunk boxer and threw in the towel. I can sort of understand it. The government have stage managed this masterfully, whipping up a fear of a future LNP government rolling out fracking across the state and putting the opposition into a position where opposing this nonsense legislation would somehow make the myth a reality. I can understand it, but that doesn't mean that I'm not disappointed that they haven't tackled this bill on its merits rather than on how they might be perceived. Let me make my position on this bill. It has absolutely nothing to do with fracking whatsoever. I'm not going to talk about whether fracking is a good or bad thing, what the experts say about it, or what the community views are. These issues are all irrelevant to this bill. What this bill is actually about is the critical question of whether the Parliament, and through the Parliament, the people of Victoria, have supremacy over the law. As members of the Commonwealth, our governments, state and federal, have inherited their constitutional and government traditions from them. Maybe it's too bogged down in the complexities of constitutional scholarship, but it seems that the government and many members of this place are fundamentally disinterested in the traditions of our liberal democracy. It's impossible to explain why this legislation is so thoroughly awful without laying the context of where our constitution and the powers of our parliament are derived. When Victoria established our first constitution back in 1855, there was a recognition back in the United Kingdom that the colonies needed freedom to govern themselves. You could say that the lessons from the United States declaring themselves independent of the Commonwealth were very much in mind. As was, and still is, the Convention, to uphold the primacy of the Parliament in creating laws, the only power that Parliament was restricted from exercising was restraining its own powers to make laws. This was Section 5 of the Colonial Laws Validity Act 1865. In the 1970s and 80s, several of our founding documents were updated to become purely Australian and replace old colonial laws. One was our own constitution, updated by the Constitution Act 1975, and the other one was the Australia Act 1986. This replaced the old Colonial Laws Validity Act. It is this Act which empowers the various state constitutions, and through these powers, our state democracy is shaped. The significance of this Act was recognised at the Times, with all of the states and territories involved in negotiating the various sections until a consensus was established. For the purposes of our debate here, the most important sections are 2 and Section 6. Section 2 essentially grants the powers to the states to make laws, but also states that the Act does not confer any powers to the state that they did not have prior to the passing of the Act. Section 6 replaces old Section 5 of the Colonial Laws Validity Act. Of particular relevance today is the negotiations that occurred leading up to the introduction of the final bill. The idea of entrenching ordinary laws into the Constitution was most definitely discussed, as Professor Anne Toomey noted in her book titled The Australia Acts 1986, Australia's Statutes of Independence, which is in the Parliamentary Library. And I quote, "If the states had wished to extend their powers so that they could entrench any law, they could have chosen to remove the restriction to laws concerning the Constitution, powers or procedure of the Parliament, but they chose not to do so." End quote. What is meant by this is that Section 6 of the Australia Act restricts state parliaments from enshrining in the Constitution anything that isn't related to the powers or procedures of Parliament. To be clear, they can do it, but it's likely that it's legally ineffective. And to put it in very plain terms, the bill that is being debated today is absurd posturing based on a legal fiction. The significance of the Australia Act 1986 is highlighted by the fact that Her Majesty Queen Elizabeth II came to Australia to personally sign the Act that completed the process of constitutional and legal independence for Australia. We heard from some of my colleagues on the crossbench this week that they had sought advice from the Solicitor General regarding the complexity of drafting specific laws to manage the pandemic, and at least partly based their decision to support a 9-month extension of the state of emergency based on this advice. If they consider the Queensland Solicitor Generals to be equally competent to provide independent advice, they should oppose this bill. In 1996, the Queensland Parliament repealed a presumably entrenched provision of their constitution related to the means of appointing public servants. The view that was taken was that the law for the repeal was not a law with respect to the constitution, powers or procedure of the Parliament, and there was no other valid source of power for such entrenchment. This view was supported by the advice of the Solicitor General, the Crown Solicitor, Professor Finnis and the Electoral Administrative Review Commission. The majority of legal opinion and case law suggests that this entrenchment would be legally ineffective and could be amended by a simple majority of a future Parliament. This means that legally it is no different than the existing ban. While this is the majority opinion and the personal opinion of Professor Toomey, the leading expert on the Australia Act, and Professor Taylor, the leading expert on the Victorian Constitution, which is also in the library, it has not been definitely determined by the courts. It seems that this narrow window of doubt is what the government is relying on for this debate. The principle here goes far beyond any discussion of the pros and cons of fracking. What is of concern here is the precedent where the government of the day can enshrine in the Constitution any policy at all. If there are no limits, then there are absolutely no limits. Will our Constitution in 200 years be littered with snippets of archaic policy no longer relevant to the situation of the day? Will future democratic parliaments be undermined as they are ruled from the political grave of their predecessors? Will future citizens of Victoria be denied full access to democracy? The Statement of Compatibility with Human Rights Charter, tabled by the Minister, completely fails to recognise that the legislation may engage Section 18.2 of the Human Rights Charter, taking part in public life. The Scrutiny of Acts and Regulations Committee was slightly better, at least recognising that the bill may limit people's ability to participate in public life. Unfortunately, this is simply hand-waved away, stating, and I quote, "Clause 3 may be a reasonable limit on that right for the purpose of protecting the environment and the rights of landholders," end quote. If this is accepted, then it is hard to imagine any kind of restriction on altering future environmental laws that might be put in the Constitution. Based on the Statement of Compatibility, the work done by the SARC committee and the debate that has occurred in the other place, I am not convinced that there is a good understanding of how the Australia Act interacts with our Constitution, the implications of allowing any policy at all to be entrenched in the Constitution, and the historical case law on these matters. As such, I will be moving a reasoned amendment to delay passage of this bill until there is a more substantial inquiry into these matters. I urge members of this chamber to consider the significance of this bill, not just as a question of environmental protection, but as a critical question related to the powers of this parliament to make these laws. The Liberal Democrats cannot support this bill.
Mr Limbrick, before you sit down, can I ask you to move your amendment so we can circulate it?
I would like to move my reasoned amendment now, please.
So it's all recorded before you sit down, so you don't miss out.
Being a libertarian is sometimes described as like being the only sober person in the car and no one will let you drive. The government is driving us into the dark.